Hello, what's up, everyone? Welcome back. Long time no see. So, today we'll be covering the topic of causation under Criminal 1. So, without further ado, let's go. Okay, in Criminal 1, we have learned the concept of actus reus, mens rea, and as well as before this topic, the concurrence principle. So, all of this plays a part in understanding what causation is. So, basically, in a nutshell, causation is a concept in criminal law in which the accuser's act is causing the injury of the victim. Basically, apa yang accused to buat is the direct or substantial cause to the victim's injury, the victim's death, and so on and so forth. Okay, so this concept states that from the act of the accused until the injury incurred, there must be an unbroken chain, which means that here, if you look at my little illustration here, this is actually a chain from which the first link the first link of the chain, which is the accuser's act, forms a chain sampailah the last link, which is the injury. So it is unbroken. Okay, that is the basic concept of causation. Okay, there are two types of causation. Don't mind the um, heavy rain outside. It's actually raining cats and dogs right now. So there are two types of causation. First is factual causation, which uses the but for test. I'm sure a lot of us are very much familiar with the concept of the but for test because we have covered this test so many times before. So I won't really go into it. Secondly, legal proof, which states that the defendant or the accused actions sufficiently caused the injury. Okay, this is usually used for when there are multiple causes towards the injury or the death, and the court has to determine whether the accused action was the substantial or the substantial cause towards the injury or the death. Okay, those are the two types of causation. Okay, in the case of Mills, if I'm not mistaken, this is public prosecutor against Mills. The accused act must directly link to the death and not merely remote. Okay, that means that if the accused did something, and that something that the accused did, that thing was one of the many causes of an injury or a death, the court must determine whether or not that thing that the accused did was the substantial linked or the direct link to the death or the injury, and not merely remote. That means it cannot be one of the many in which that one thing that he did is a minute or a small contributor to the injury. Okay, we are done with the overall concept. Let's look at the concept of rashness and negligence as well as knowledge and intention. Okay, in the concept of rashness and negligence, this is covered in section 304A of the Penal Code, in which it basically outlines the concept of rashness and negligence lah, because this is a form of mens rea, a level of mens rea, which is then covered by definition in respective provisions. For rashness and negligence, it is 304A. Okay, basically just gonna dive. It's This topic actually is a little bit of a lot of things. So you see a lot of concepts here and there, but not really into detail. That is why some of it is a little bit short and some of it is long. Macam tu. Okay, so in the case of rashness and negligence, in the case of Lee Kim Long, the death must result from negligence, and negligence must be proximate and sufficient for that negligence as well as rashness to be the main contributor or the causing factor towards the injury of the death. That is when the accused, who is either rash or negligent, can be held liable. Macam itulah. Okay. Secondly, in the case of Suleiman Ruhiman Mulani Air, there must exist a direct nexus between negligence and death. Okay, the concept of direct nexus doesn't really apply to negligence and rashness specifically only, because the concept of direct nexus actually is basically a fancier way to say that there is an unbroken chain. So whenever you substitute these two phrases, it basically means the same thing when you write your answers or when you are explaining it to someone. So basically, even though this case is technically under rashness and negligence, if you like substitute negligence ni dengan accused punya guilty act and death, it basically means the same thing because direct nexus, unbroken chain is basically the same thing. It is just a fancier way to say one thing macam tu. Okay. Next, the concept of knowledge and intention. This is covered in section 299 as well as section 300 of the Penal Code. Okay, moving into the case law terus. In the case of Leong Seong Soon, okay, it states that if the stab wound is substantial to cause death, liability is maintained even if other factors contribute. Okay, actually a lot of these cases macam tak adalah really explain what knowledge and intention is, for example, or this case doesn't really explain what rashness and negligence is, for example. But these two are actually forms of mens rea, levels of mens rea, and these are the necessary things to know when you are writing what causation is. Basically, macam tu. That's why it doesn't really go into depth. But I'm just going to touch on it, okay? Okay. Now, novus actus interveniens. I'm sure you have heard of the term novus actus interveniens, especially if you have paid attention in third class, which is the third party intervention or intervening act. Third party intervention is a form of novus actus interveniens. So, novus actus interveniens is an intervening act that breaks the chain of causation. So, if I may, like draw a little bit, for example, this is the unbroken chain. Tiba-tiba novus actus interveniens is right here. So novus actus interveniens, NAI. When it happens here, the chain breaks. So you can see that from this unbroken chain, this long unbroken chain, there is now a missing link that does not connect, that is supposed to connect these two larger pieces together. But since this link is broken, it breaks the chain of causation. That is what novus actus interveniens is. Okay, so in the case of R against Smith, in this case, there are two causes of death, if I'm not mistaken. I'm not sure if it's death or something, but the court said that if the second cause is so overwhelming that makes the first cause merely part of history, only then will that second cause break the chain of causation. Maksudnya, in this timeline, okay, contoh in one timeline, we have two events which lead to death. So draw a little skull here. Uh, okay, so draw a little skull here. So this is the start. This is when he is alive. So the first event is contoh the stabbing. So I'll draw a little knife here. Then maybe this is the surgery. So I don't know. Lukislah a surgical benda, I don't know what this is. A surgical scissor or something. So, if contohnya the first event induced the second event to happen, but the death of the victim was caused by the negligence, macam mana? Something that is in this second episode of the story, and if that thing that happened here was so substantial and so large that when you look at things from a larger view, this initial stabbing seems even smaller when compared to the events of the second episode. So this is when the second cause breaks the chain of causation. Macam tu lah. I hope korang faham lah. But it's been a long time since I've explained, so I'm kind of all over the place macam tu. Okay. Okay, next. This is my marker. Okay. There are few categories of causation. Four main actually. One, two, three, four. First is medical treatment. So basically, we're gonna touch on the types of causation. We'll go into the provisions and case law terus. So first, medical treatment. In the case of R against Steele, proper treatment does not absolve liability. This can be seen in explanation 2 of section 299 of the Penal Code. Basically, to sum it up, what these two things mean is that if there is an injury that occurred to a victim and the victim was given proper care, contoh dia dibawa ke ICU and that ICU restored him to his original condition, that doesn't mean that the accused who stabbed the victim was absolved of any liability sebab he is still liable for the act of stabbing itself. Macam tu. That is what two of these things mean. But in the case of R against Jordan, this is not but macam tapi per se. In the case of R against Jordan, negligent medical treatment also does not absolve liability, because even if the doctor is negligent or rash in his delivering of, I don't know, the treatment, it does not make the accused who stabbed the victim initially absolved of any liability, because okay lah, katakanlah if I stab someone, orang tu dibawa ke hospital, doktor dekat hospital tu pula, I don't know, careless ataupun terlepas pada a few things, does that automatically make me not liable? No, because I still stab that victim. Macam tu. Secondly, victim's voluntary intervention. There are two types of voluntary intervention. Firstly is escape of flight, fight or flight. Secondly is the eggshell skull rule. Okay, first, escape or fight or flight. In the case of Jaginder Singh, the court held that there was no proof that the accused forced a victim to jump into a well. So, the victim lompat masuk perigi, but there was no proof that the victim was forced to do so. So that means that the victim voluntarily jumped into the well. Hence, whatever happened to him was not on the liability of the accused, because the accused did not force the victim to jump into the well. Okay. Secondly, is the eggshell skull rule. Okay, the eggshell skull rule is basically what we have learned in thought, which is you take someone as he is, as she is, because you cannot assume that everyone is good and healthy, because doing that would be prejudicial. I don't know what the term is. Macam kau assume yang orang semua sama, then what happens to orang yang maybe macam okay you macam tu lah. Something like that lah. Okay, the eggshell skull rule is explained in explanation 1 of section 299, in which explanation 1 section 299 states that if someone, I can't remember, okay, a person who causes bodily injury to another who is at that time actually having some sort of disability or disease, and if that thing happens to accelerate or to worsen his condition as to cause an injury or to cause death, the person who does that thing to the person yang tengah suffering those diseases is held liable for doing that thing, because they are considered expediting or accelerating the process of him becoming worse lah per se. It's not worse pun, because you cannot help having a disease, but your condition is worsening because of what the accused did. Therefore, he is liable for that. Macam tu. So, in the case of Bharat Singh against Emperor, so in this case, the victim's abnormal heart size reduced the accused charge because the apa ni? OP. Okay, since ordinary persons cannot foresee that the victim had an abnormally huge or abnormally small, basically abnormally sized heart, macam tu. That is where the charge is reduced lah, because he couldn't foresee that the victim had a disease or had a condition, macam tu. Thirdly, victims believe. In the case of R against Blaine, the victim was a Jehovah's Witness and he could not receive blood transfusion due to his religious belief, and hence the victim died because of that. However, the mere fact that the victim was a Jehovah's Witness, he couldn't receive blood transfusion, did not break the chain of causation. Therefore, the accused was still held liable. Lastly, third party intervention. In the case of R against Payat, I don't know, the police did accidentally shot a girl used as a human shield. So, if I may demonstrate lah, lama tak buat video kan, so a bit extra lah today. So, bayangkan ni budak kan, I am the accused, this is the girl, I took the girl as a human shield. The police accidentally shot the girl who was acting as a human shield masa tu. Tapi, it did not break the chain of causation. Okay, macam tu lah. Basically, a lot of this thing, categories ni, ada je dia punya cases yang say the opposite of the cases that I'm referring to. But since it's like I say, causation is a little bit it's a mix of a lot of things. So I cannot possibly cover everything. just to like answer one small part of the question. Macam tu. So that is it. I guess that's it. See ya.